There have been a lot of issues and very interesting cases on this whole area of retirement ages. And I keep speaking about this practically every year because there has never been any great clarity. And indeed, so as 2011 came to an end, I think we're beginning to get a grip in this country about how we deal with retirement ages, okay? Now, let's just go back a couple of years ago. There's no fixed retirement age in this country, okay? So that issue, as there is indeed in other countries, and particularly in the continent. So in this country, the government devolves that responsibility for a retirement age to individual employers. So it's up to you as an individual employer to determine what your retirement age is in your company or organisation. Most employers in this country either have a retirement age in their contract or it's there by implication through their pension scheme, which says you must retire at age 65. So this has been an ongoing issue for employers over the last number of years. Well, is that discriminatory within the context of the Framework Directive? Now, the 1998 Act, as amended, the 1998 Equality Act, under section 34(4, says it shall not be discriminatory for an employer to impose a retirement age on employees. Okay, so what does that mean? It means that all employers can say our retirement age is 65, and that's not discriminatory in terms of age. That's what the Act says. However, it's widely accepted that section 34(4 is not consistent with the Framework Directive. So there have been a huge increase in this area before the EAT and the equality decision. I'll deal with the Employment Appeals Tribunal first because they look at this very differently from the Equality Tribunal, okay? And when you're considering this in your own areas, you might just want to, if you could parcel this into say, well, okay, how do I deal with this issue of retirement? I can deal with it on the basis of the contractual way that the Employment Appeals Tribunal can deal with it, or I can deal with it on the basis of is it age-based discrimination on the way the Equality Tribunal deal with it. Okay, so there's two very great distinctions. Now, there have been a number of interesting cases in this, and the first of those is the Connacht Gold case. And in this instance, the Employment Appeals Tribunal ruled that the agribusiness group Connacht Gold was entitled to enforce a nominal retirement age of 65, despite a lack of reference to retirement age in relation to the claimant. There was no written contract of employment in this, and the bulk of employees actually left at 65, but 2 employees continued beyond the age of 65. There was a reference to retirement age in the pension scheme only. Now, in this regard, the Employment Appeals Tribunal look at this from a very contractual perspective. They said, well, okay, the normal retirement age in the company, which is what the Act demands, that you look at the normal retirement age, is 65. And they said, look, because 2 people extended beyond the age of 65 for a period of time, doesn't change, in inverted commas, the normal retirement age. So they deal with it on a very contractual basis. What is in your contract of employment? And if it's not in your contract of employment, what is the custom and practice? And if the custom and practice is that, even though there might be some blips in that, then that remains the contractual retirement age. So the case of Fuchs and the Landhesen is an interesting case before the ECJ. And this held that a provision of German law stipulating that the retirement age of 65 for permanent civil service did not breach the EU Equal Treatment Directive. This case involved 2 prosecutors who retired at age 65. That retirement age could be extended to age 66 by agreement. They weren't allowed to go beyond the age of 65. And they alleged then that retirement age breached the prohibition on age discrimination in the Equal Treatment Directive. And the ECJ actually held against them in that regard, okay? And they said that it could, first of all, they started from the point that, of course, it's discriminatory to have a mandatory retirement age, but it's not if it can be, if it's based on objective and justifiable grounds, okay? Now, there's another interesting case which I haven't on the slide here called CHC, and this case involved a winchman who worked for this helicopter company. He's the guy that comes down out of the winch and saves you if you're in some degree of peril. And the retirement age in that instance was age 55, and CHC sought to implement that retirement age when they reached age 55. And the 2 winchmen said, no, they should be allowed to extend beyond age 55, and that it was discriminatory on the basis of age. Now, the equality officer in that regard took a look at the whole issue, and he said, okay, given the need for strong people, he looked at the whole issue of muscle development and so forth. He said that it could be, and the need to actually protect the employees themselves, the need to protect who they were trying to save, that retirement age of 65 could be a legitimate aim based on objective and justifiable criteria. So you're stuck with this issue now to say, okay, how do I deal with the issue of retirement ages? Well, first of all, you must look at it from a purely contractual perspective first off. You'll look at it and you'll determine, well, okay, on the basis that our contract says you must retire at age 65 or 66, that's the contractual issue, okay? Moving on from that then, okay, if it's not a contractual issue, can I, and I don't have it in the contract of employment, or even if I do have it in the contract of employment, what are the objective and justifiable criteria that I can use to make a retirement age stick at age 65 or 66, whatever it might be?